May it please the court?
Yes.
Andrew Berman, Special Assistant District Attorney on behalf of the Commonwealth. At council table is Charlotte Bednar and Peter Carr on behalf of the defendant, William O'Connell. Excuse me. I'll be addressing the issues relating to the statutory interpretation of 97D in Chapter 276, 2B, and I'll try to address the issues raised by Justice Lank in the report and reservation. The first of which is whether or not affidavits supporting applications for search warrants and the accompanying search warrant materials in cases involving allegations of rape and sexual assault constitute reports or conversations within the meaning of Chapter 41, Section 97D. I think that it's eminently clear that a report is a report. If that exact same affidavit in support of the search warrant, which was submitted to the clerk magistrate, existed in the police file at the police station, I don't think anybody could reasonably question that that is a report within the definition of the statute, and it also contains conversations which would be covered by 97D as well. The legislature made it very clear by using the terms all reports and all conversations that the statute should apply to exactly that. The statute does not limit itself to official police reports in the possession of the police department.
Well, you say that, but the language of the statute says, and shall be maintained by the police departments in a manner which will assure their confidentiality. The legislature knows the word courts, didn't use the word courts, spoke only of the police department. Why is it not appropriate to say that this says that police reports in the possession of the police department are not subject to the public records law?
Well, I think, first of all, because that's not what, respectfully, Your Honor, the statute says.
Show me where it says anything other or means anything other than that the public records law shall not require the disclosure of these police reports, and they are not subject to be disclosed pursuant to the public records law. When the language of the statute specifically says shall be maintained by the police department, what do we do with that language?
Well, I think there's a difference between imposing a restriction on police departments and concluding that that is the only restriction in place, because once they're determined to be non-public records, there's a litany of procedures and statutes and case law governing non-public documents once they're submitted to the court. So for the legislature to make a specific reference to the obligations of police departments in maintaining these records, I don't think has any bearing on the well-established obligation of courts and prosecutors and defendants to ensure that non-public documents are not disclosed. I think the reason, to answer your question directly, that specific sentence is in there is because there is no existing case law or statutes relating to documents within the possession of police departments, while there is ample case law and procedures relating to non-public documents once they're deemed to be non-public.
And that case law says that documents are presumptively public, and you're saying that this statute is intended to override our common law regarding the presumptive public nature of filed documents. But that doesn't do so terribly clearly, so doesn't that mean that we don't infer that the legislature intends to change the common law unless it does so more clearly than this statute does?
I don't think that the legislature can get any more clear than saying all reports and all conversations. Yes, the 276 Section 2B does apply very generally to affidavits in support of search warrants, shall not become public documents until the affidavit is returned. But that, respectfully, Your Honor, needs to be interpreted in the context of a later enacted, more specific statute of 97D. The legislature could have used terms official police reports, all reports in the possession of police departments while maintained at police stations. The court did not do that. And I think that one of the cases which we cite, Montefusco, and I know it's not directly on point, but it's in the brief for the proposition that 97D applies to something other than reports that are in the possession of police departments, because the reports in question in Montefusco, if there even were reports at all, relate to documents that were in the possession of the district attorney. So I think this court has, at least in passing...
Do we know what the nature of those reports was in Montefusco?
We don't, Your Honor.
So they could have been police records that were in, these kinds of records that were being maintained by the police department that the district attorney would have had access to.
I'm not sure I completely understand your question. My understanding of the documents that would have been in play in Montefusco would be the documents that would typically be involved in the course of a criminal case. Everything from...
But you don't think they were 97D type documents?
I don't know, is the answer to your question. I don't know if what the district attorney had in his possession was affidavits in...
Not affidavits, records or conversations that the police would have had to maintain under 97D. I thought that was what you were citing Montefusco for. Well,
I was citing Montefusco for the proposition that 97D does apply outside of a police department.
So these would be 97D type documents, is what my point is.
I believe
you presume that's the case.
I presume by the court's reference to 97.
That somehow those 97D documents were then in the possession of the district attorney.
Sure.
Because the district attorney could have access to what the police department has access to.
Precisely, and presumably there would be police reports, official police reports, in the possession of the district attorney relating to Montefusco's underlying case.
And so what we did was basically say those don't have to be turned over as part of a public records
I think law. The court ruled on other grounds, and that is that it was a post-trial motion and the defendant had not met the burden of the rule in obtaining those materials. I think in all fairness that language in Montefusco could be classified as dicta, but I do believe that the court's reference to it in the context of somebody attempting to obtain materials in the possession of a district attorney would counsel towards the interpretation of 97D as applying to something beyond just reports within the possession of the police.
Can I ask you to follow up on the statement I think you made before, which is that there's ample case law and procedures dealing with non-public documents. So these are documents that, could you tell me what you mean by that?
Well, there are statutes in place. There's a uniform procedure for impoundment of documents. Your Honor, there are statutes in place relating to redaction of the name of a victim of sexual assault. There are statutes in place governing information.
This is what happens with this. I'm sorry, but I mean, are these things that relate to documents that are filed with a court?
Yes, yes, documents within the possession of the court, which by statute, various statutes, are not public documents, are not disclosable, are kept confidential. And just as an example, I'm sorry.
No, go ahead.
So just as an example, there's 258B section 3H, the residential address and telephone number or place of employment, and various other information relating to the victim or the victim's family member is by statute, if the victim so moves, not disclosable. There is General Law, Chapter 272, Section 105. Photographs of an unsuspecting nude person are not deemed to be public documents.
But following up on that question, would you have to say that 97D applies to, let's assume this search warrant affidavit is filed in the court. Is it not possible to implement whatever might be the applicable statutes that you're now referring to without ever getting to 97D?
Because 97D is much broader than the statutes that would normally apply in the context of sexual assault.
So I guess I'm just clarifying. You're not suggesting that the only way you get to those other statutes is through 97D?
Not at all. I'm just saying that there are laws that relate to the impoundment of documents in a court that I think reasonably could have led the legislature not to address that specific point in 97D and only limiting the last clause of that sentence to police reports maintained in the possession of police departments, because the procedures are well established to obtain an impoundment order in court. You simply file a motion and you cite the relevant case law and statute. I don't think that it was necessary for the legislature to include information that would carry 97D over to the courthouse, because those procedures and regulations are well established.
But isn't another way of looking at that 97D wasn't intended to apply, and that the remedy is through those other statutes?
Well, that's the question. The other statutes would not be as
I understand that, but
would be more specific as 97D. I mean, that's exactly the question. Does something that is a report in a police file somehow transform into something else as it's being transported from the police station to the courthouse? If it's a report, then it's a report then and forever. I don't see respect.
But it becomes an affidavit, and maybe the affidavit has things in it besides what's in the report.
It's the portion of the affidavit that relates to a report or conversation that I think is at issue here. I mean, the officer's rendition of their experience, I would concede, would not be governed by 97D. It would have to be something that's specifically set forth in the statute, all reports and all conversations relating to an actual or attempted sexual assault.
So
excuse me, I'm sorry. We're 2 minutes over.
My apologies, Your Honor.
It's been over for a while.
My apologies. Thank you. I didn't take note of that. I'm sorry.